Assalamualaikum. My name is Nurizani Ahmad, metric number 2013232. I will be presenting on fact of the case for Carlill versus Carbolic Smokeball Company. During an 1891 influenza outbreak, Carbolic Smokeball Company widely advertised their product, the Carbolic Smokeball, in the Pall Mall Gazette newspaper. The advertisement claimed that by using the product according to their recommended dosage and instruction, the user will be immune to the influenza or any other types of similar diseases. The company instructed users to use the Carbolic smoke ball 3 times daily for 2 weeks using the printed step given with each ball. They then offered a reward of £100 for users who still contracted the influenza even after the user used their product according to the instruction provided. To further advertise the product, the company even went as far as showing the proof that they had deposited £1,000 into the Alliance Bank to pay out customers who contracted the influenza after using the Carbolic smoke ball. On seeing this advertisement, Mrs. Louisa Elizabeth Carlill, the plaintiff, went and bought the Carbolic smoke ball at the chemist in Oxford Street. However, she contracted the influenza even after accurately following all the instructions given. Mrs. Carlill had tried to claim the promised £100 with the company, but they refused to pay her. She proceeded to file a lawsuit against the company for breach of contract, in which she won. The trial judged that the company should pay Mrs. Carlill £100 as promised in the advertisement. The Carbolic Smokeball Company appealed the decision to the Court of Appeal, but it was later dismissed.
Assalamualaikum warahmatullahi wabarakatuh. My name is Saliman Mona and I will be continuing with the issues that can be identified relative to the case. So from the fact presented previously, the issues that we can identify are firstly, whether Mrs. Carlill and Carbolic Smoke Bar Company were bound by the reward contract in the advertisement. Secondly, it's whether the reward contract should be formally notified as accepted in order for it to be put in place. As for the third issue, if the advertisement was an offer, was the plaintiff, which is Mrs. Carlill, required to directly communicate her acceptance of the offer to the defendants? And lastly, did the plaintiff provide consideration for the defendant's promise to pay the reward? Basically, whether Mrs. Carlill provided any consideration in exchange for the £100 reward as mentioned in the advertisement.
Assalamualaikum. My name is Nurhabika, metric number 1926580, and I will continue with the reasonings behind the judgment of this case. So the first reason that the judges stated is that the offer in the advertisement is binding enough given that it is a unilateral offer, which means that acceptance is not required given that it is made public to the world at large. This means that anyone who consume the smoke ball are considered as the offeree, be it Ms. Carlill or anybody else. So the second reasonings behind the judgment is in the statement of £1,000 is deposited with the Alliance Bank, showing our sincerity in the matter by the company, which has clearly portrayed the offerer or the company intention to promise rewards in case things go south. This statement lead the customer or the potential customer to believe that they are promised rewards by the offerer. So as we all know, intention plays very important role in the law. So the judge stated that there is a clear intention and promise made to the offeree in this case. The final judgment or the final reasonings behind the judgment for this case is that the notification of the acceptance need not precede the performance, since Ms. Carlill has performed specific conditions or has followed specific instruction at the packaging of the smoke ball, which means that she has performed the conditions to imply that she accepts the offer or the promise by the company to be in contract with them.
Assalamualaikum warahmatullahi wabarakatuh. My name is Narisa Soya, metric number 1818504. I will proceed with the judgment regarding to the court decision. So the judgment of the case is decided by the Court of Appeal in United Kingdom, and the court held that there was a fully contract between defendant Carbolic Smokeball Company and plaintiff, which is Mrs. Carlin, and because there was a fully binding contract, Mrs. Carlin won the agreement and she was entitled to the reward for £100 as has been stated in the advertisement. Consequently, the Carbolic Smokeball Company lost its agreement. Although the company appealed to the court straight away after lost the agreement, the court immediately rejected the company appeal and held that there was a fully binding contract.
Assalamualaikum warahmatullahi wabarakatuh. I'm Sarah Fazana binti Rizwan and I'll be discussing regarding the principle used in this case, which is contract law through unilateral contracts, a one-sided agreement of legal contract in which one individual or the buyer pays for a specific action from another party. Therefore, in this case, the contract was fully legally binding. Thank you very much.
Assalamualaikum, my name is Nur Atina binti Abdurrahim and I will be talking about the analysis of the case. We agree with the court decision as we believe that the offer deserved to be rewarded. Because the advertisement characterized the essential attributes of a unilateral contract, the contract between Mrs. Carlill and the company existed. Besides that, a valid general order was issued to the public, giving a meaning to newspaper readers that the small ball was not only a sale of goods, as the corporation deposited certain pounds in the bank as proof. This portrays the intent to form an agreement from one party to the other party. The terminology used by the company was not ambiguous, which leads the newspaper readers to understand it. Thus, this case might have occurred even if the plaintiff was not Mrs. Carlill. Lastly, although the rule of transmission of acceptance is required, the company may opt out of the requirement for notification since Mrs. Carlill has performed an implicit act to show her willingness to be in a contract with the offer by completing the required usage as instructed on the package.